Professor Sverna, I'd like to introduce Mr. Manjula De Silva. He's the CEO of Ceylon Chamber. I'm not sure if you met already. And we have Sonali Vikramaratne and Shenuka Jala, who will be joining us for the panel discussion later after your keynote.
Okay.
Yeah.
Hi, Professor. Good to see you. From where are you joining? I should probably say good morning to you.
Thank you. Good morning. Good afternoon.
Or is it afternoon? Depends on where you are. From where are you joining, Professor?
Hi, Raina. Nice to see you.
Nice to see you.
Hi, Raina.
Hi.
I think we'll start in about a minute. Okay.
Yeah, let me know, Sandhini, when you're ready.
Thanks, Manjula. Hi, Janta.
Hello. Should I wear a jacket? I can see Manjula is wearing one, so I'll get a jacket before I come home.
Hello.
Oh, no worries, Janta, no worries. We just standard practice. We got a couple of things coming up.
Good. Nice seeing you, Manjula. And I just came rushing back to the room from the event downstairs taking place. It's nice to be online. Thanks for hosting us, Manjula. Thanks.
You're welcome, and thanks always for your support.
Manjula, it's a pleasure to meet you. I haven't met you. I'm Sonali. I head internal audit for Virtusa.
Hi, Sonali. Hi.
Hi.
Yeah, you too. You're based here, Sonali. Where are you operating from?
I'm based in Colombo.
All right.
And we can start now.
Yes, you can.
Right, I'll start off. So let me wish everybody a good afternoon or good morning, depending on where you are joining from. We are going to kick off the second in our series of awareness workshops on the Personal Data Protection Act that was passed recently, which goes as number 9 of 2022. For those of you here in the audience, the lawyers who are concerned about the detail. And this program, as most of you know, is being organized by the Ceylon Chamber of Commerce in collaboration with Meta. So we had the first workshop in the series, which focused on the salient features of the Act itself and provided a broad overview of the provisions of the Act. And this was very well received. We got some excellent feedback, which was used actually to some extent in designing the second workshop, which we are just about to get into in a moment. But before actually coming into the focus areas of today's workshop, I want to make a comment that this act actually we saw as a culmination of a long period of private and public sector consultation and collaboration. So typically we find a lot of legislation goes through without much consultation with the private sector, but we saw in this instance a great effort being made to get private sector input. And I'm happy to say that the Ceylon Chamber played a significant role in providing that input with the support of our legislation steering committee in particular. And I must also greatly appreciate the role played by Mr. Jayantha Fernando, General Counsel of ICTA, for facilitating the dialogue because he made sure that our inputs were received and also were considered in drafting the final act. So that was, I think, an excellent example of how the public and private sectors can work together. And without ending our collaboration at that point, we thought of taking it forward through a series of awareness programs. So which is what we are seeing happening right now. So we had the first workshop, as I mentioned before, and this particular version will focus particularly on the IT industry and also on the telecommunications industry, two sectors for whom this act will be of great significance and relevance. But of course, we are not going to confine today's discussion only to the act itself, but we'll also explore other related areas as well, trying to draw from the experiences of other markets as well. So we have a very eminent panel today of international and local resource persons. So let me very quickly introduce who's on the panel today. As the keynote speaker, we have Professor Jerit Jan Swen. I hope I got your name correctly. He's a professor of law and digital technologies at Leiden University. And so after his presentation, we will also have a fireside chat with him that will be moderated by Ms. Sanduni Vikramasinghe, our consultant on information technology and privacy law, who is playing a very valuable role in actually putting together this series of awareness programs. And then after that, we are going to also have a panel discussion where we'll have Ms. Reina Jung, Head of Privacy and Data Policy Engagement APAC of Meta Incorporated. Warm welcome to you too. And then, of course, Mr. Jayanta Fernando, General Counsel, ICTA. I don't think without whom any program on this subject can go ahead. I mean, today is one of the most sought after speakers on this subject, as he was very much an architect of this process. Then we also have enriching the panel, two other resource persons, Ms. Sonali Vikramaratna, Global Head of Internal Audit of Virtusa. Happy to have you here, Sonali. And also Ms. Shenuka Jayalat, Manager Regulatory of Dialogue Asiata. Welcome to you too, Shenuka. And so we really look forward to a very interesting session today. And that panel discussion will also be moderated by Sandhuni. So that's basically just by way of brief welcome and introduction to the session. With that, let me pass you on to Sandhuni to take the program forward from here. Thank you very much, and I wish you a very enjoyable session.
Thanks, Manjula. Thanks for the kind introductions. So for the, just to recap of what we discussed in the last workshop, I thought to help the audience to get some perspective as to what went on during our first workshop a month ago. So basically, we spoke about the background to the PDPA, which was delivered by Mr. Jayanta Fernando, and how the drafting process took place. And his session also drew reference to the key definitions as contained in the Act, the definition of personal data, controller, and processor, and so on. And he also spoke about the scope of application of the PDPA, how, and he illustrated how this Act would have an extraterritorial application as well. So that will cover controllers who are not just located in Sri Lanka, but also outside of Sri Lanka, who perform systematic profiling or targeted sale of goods to goods and services to data subjects here. And he also shed light on the powers and functions of the Data Protection Authority, which is going to be set up in the future, covering its powers to issue directives as well as penalties. And he also spoke about the cross-border data processing framework, which is embedded into the PDPA, and how that will be facilitated once the Data Protection Authority is set up. And in the next session, I spoke about the different powers, the different obligations of controllers and processors. Here we spoke about the principles of processing, lawful principle, purpose specification, purpose limitation, and so on. And I also discussed about obligations that are exclusively processors, things processors needs to look out under the Act, and obligations that are common to processors and controllers. So in this discussion, we also discussed various rights of data subjects that have been granted under the Act, and how controllers and processors need to look at these rights in terms of giving effect to these rights. And Mrs. Sujit Christie in his session spoke about information standards for PDPA compliance, and he spoke about the impact of key factors in data breach, and he illustrated the data lifecycle management and its essential components, and advised the audience about devising an effective organizational monitoring mechanism within a controller's operational framework. And the next session was devoted to workplace privacy and PDPA, which was done by me. And here I spoke about the application of data processing principle in the context of employment, and what are the things an employer need to be mindful of when processing personal data of employees as a controller. And we discussed also about the rights of employees as data subjects, and the best practices what a controller needs to follow as an employer to be PDPA compliant in the workplace. And finally, a presentation was done on the concept of privacy by design by Professor Anne Cavourkier. She spoke about dispelling certain privacy myths, and she illustrated the 7 foundational principles of privacy by design and discussed extensively on the positive sum over zero sum approach when designing new systems and technologies going forward, and about the aspects of operationalizing privacy by design in a business context. So with that, brings us to today's workshop. So today's workshop is focused on the telecommunication services industry, as well as the technology services industry, as well as the telecommunication sector. So the reason why this particular industry has been chosen is because it's important that players, stakeholders in this sector understand the different roles they will have to play as controllers and processors when the act comes into effect. Because what we understand is that tech service providers come in all shapes, forms, and sizes. So they could be product builders, they could be middleware service providers, or provide certain services to both private and government sector. And on the other hand, the telecommunication industry also operates in a large-scale data aggregating mechanism, and they provide various services, including internet services and other communications channels to the general public. So it's important that these various stakeholders understand their roles as both controllers as well as processors in various data processing operations. And it's important that they are in a position to understand what obligations they have and challenges that they might face during their compliance journey under the PDPA. So we have lined up a collection of experienced professionals and speakers in this sector who have graciously agreed to share their expertise in the field. So without any further ado, I'd like to invite Professor Werner, who's joining us from Geneva. And just to give you a brief introduction, Professor Werner is a professor of law at Leiden University in the Netherlands, and my own professor of data protection law when I did my advanced master's program in law and digital technologies. He accounts for more than 30 years advising private and government entities, focusing on the application and effects of privacy and data protection law and regulation, and on telecom and internet law issues, including cybersecurity. He's also a partner at law firm Peirce & Reichen in The Hague. So I kindly invite Professor Werner to deliver the keynote address. Thank you.
Thank you. I'll try to share my screen. And there we go. Thank you, Sanduni, for this wonderful introduction and this invite for this webinar. Yes, what I wanted to do in the 20 minutes that was assigned to me, 20-15 minutes, to discuss 3 compliance issues that I've dealt with in my capacity as an attorney at law at my law firm, advising the government, advising other entities on data protection compliance. All from my personal experience, but most of it is already made public, especially when you advise the government. Your advices may become at some point sent to Parliament and then become public. So without compromising my professional secrecy, I can discuss this with you. Well, this is me. It's a bit of a boilerplate PowerPoint slide. You see a photo of me. Actually, that is processing personal data. And according to some, you could even say this is processing of sensitive data, special data, because you can see my glasses, and that says something about my eyesight, which could be considered health data, according to some. My first example, the first issue I'd like to discuss with you, personal data or not, using telecoms location data to monitor the corona pandemic. In the Netherlands, in Europe, all member states wanted to use location data extracted from cell towers of telecoms companies to monitor the progress of the pandemic, to assess the effectiveness of the measures that were taken. And for instance, you can see in this clip that in Switzerland, which is not an EU member state, but they're very close to the European Union, this actually worked because the government could access location data provided by telecoms providers. They could slow down the pandemic and ease the measures taken. With this data, they could see that in my town, Geneva, on a Sunday, there were not too many people along the lake of Geneva, so the measures were working. People did do social distancing. Another example would be, for instance, in the Netherlands. You know, the Netherlands is a very tiny country with a lot of people. If the government in the Netherlands decides to open the restaurants and the cafes and bars, however, Belgium, our neighboring state, is still in a lockdown, then the government wants to see how many people will travel from Belgium to the Netherlands to drink a beer, a Heineken beer, for instance. And this is not about individuals. They're not interested in an individual, Mr. So-and-so traveling. No, they're interested in trends, in developments. And as you can see, in Switzerland, it worked. 24 member states in the EU use this technology with some effect. However, not in the Netherlands, not in Malta, and not in Hungary. I don't know why they didn't use this in Hungary. I expect that in Malta they didn't use it because it's a small island and you can do probably more or less the same thing with other types of data, like data of traffic on the road. In the Netherlands, there was a different reason why we could not use this technology. In Europe, we also have rules for telecommunications. We have the telecommunications directives, or I should say electronic communications directive. And with respect to telecoms location data, there is a simple rule. A telecoms provider cannot keep that data when it's no longer needed for the purpose of the transmission of the communication. And this includes also sending an invoice for the telecommunication services used by the subscribers. So if you want to use telecoms location data, you need to anonymize it. And it was a very clear starting point. And everybody thought that's no problem. Like in 24 other EU member states, this was not a problem. However, it was in the Netherlands. The European Data Protection Board, this is the body that includes all national data protection authorities. Under the regulation, the GDPR, I should say supervisory authorities. So this body of 27 supervisory authorities had drafted and published guidelines on the use of telecoms location data and also on the anonymization of such data. What do you need to do to make these data really anonymous? And a very relevant and interesting thing which they said in their guidelines was that there is a reasonability test. So it doesn't have to be 100% impossible to identify an individual. In all reasonableness, it should be not to be expected that somebody is identified through the location data. So not 100%, but it should not be too easy to identify an individual. I included some QR codes, so if you're really interested with this code, you can find this document. However, the Dutch Data Protection Authority, the Dutch Supervisory Authority, had a different opinion. And you can see the Dutch announcement on their website. I translated it using DeepL, an excellent translation program. And basically the Dutch Data Protection Supervisor said, it is impossible to make telecoms location data anonymous. You cannot do it because it is never irreversible. And this seems to be at odds with the position of the European Data Protection Board, which is strange because the Dutch Data Protection Authority, the Dutch Supervisory Authority, is part of the European Data Protection Board. So that was a bit strange. In the end, the solution was, well, there was no solution. The DPA, the Data Protection Authority, said, this is personal data, which seemed to be at odds with the European Data Protection Board, with 24 other member states. But in the end, in the Netherlands, we could not use telecoms location data for this specific purpose, because we had a discussion about effective anonymization, what is personal data, and what can you do to make it not personal data anymore. Very interesting debate, and it's all about what is personal data, what can you do to make it not personal data, to make it not qualify as personal data. Some discussion in Parliament, in the press. This is one item I recommend you to read if you are really interested in this. Was a bit politicized, but here you see Mr. Aleid Wolfsen, the chair of our data protection supervisor, and he basically stopped using telecoms location data to monitor the pandemic because, in his view, these data could not be anonymized. In my practice as an attorney at law, I see a lot of discussions about what is personal data and what do you have to do to make it not personal data anymore. And this is very key and very fundamental to data protection law. My second example, consent or not, also about the corona, about contact tracing through an app. I'm not sure that you had this in Sri Lanka, so let me explain it. This was the system that we had in the Netherlands. Individuals are invited, not obliged, you could do it, but if you didn't do it, no problem at all, but they were invited to download a contact tracing app on their mobile phones. And what did this contact tracing app? Well, it sent out codes which changed every 15 to 20 minutes. And when the user was, the subscriber was in close proximity to another user, then the codes would be stored on that other individual's device. If you were longer than 15 minutes in close proximity to somebody else, your phone would store the codes of that person. And if that person also had the app, your codes will be stored on that person's phones, and on your phone, the codes, the tokens of that individual. But you didn't have to know their name. Somebody in the park, you don't know who it is, but you were in close proximity, your phone will register that you were in close proximity for more than 15 minutes. Well, in this example, Mrs. A feels not too well. She goes to a doctor, a medical doctor, and get tested. And the doctor tells her, I'm really sorry, but you have COVID. You should go in isolation, quarantine. Do you agree that I notify this to a back-end server of the government? And then Mrs. A was asked to look in her phone for the 6-digit code. She would give it to the doctor, and the doctor would upload it But then nothing happened yet, because only when Mrs. A herself also uploaded the 6-digit code A5634F, then the backend server would send a broadcast to all users that may have Mrs. A's code on their phone. I hope this is more or less clear to you. Well, this is a typical example of privacy by design, because there are, in most cases, no personal data will be processed. There's no data that can identify an individual, but you cannot completely exclude identification. Perhaps Mrs. A has met only one individual on that specific day. Well, then she knows, okay, apparently I have been infected by somebody that can only be this individual. So you cannot completely exclude identification. So we have to, for safety's sake, assume this is processing of personal data. Although in most cases, it's privacy by design, no processing of personal data. But occasionally, you cannot exclude it will be processing personal data. And then we had a very serious debate in Parliament, in the media, in newspapers, on TV, YouTube, you name it. Okay, what is the legal basis of the possible processing of personal data? Article 6.1 in the GDPR, or it would be, I think, Schedule 1 in your Data Protection Act of 2022. And you have to understand, at that time, we did not have an act in force that would make this contact tracing possible. No act. So then the only legal basis that could be used would be consent of the user. In my view, because Mrs. A, who had the app and was asked to upload her code to the back-end server, I'd say this can be consent. She is under no obligation to do so. If she refuses, there are no consequences whatsoever. So I'd say you can do this on the basis of consent. However, the GDPR has a definition of consent: any freely given, specific, informed and unambiguous indication of the data subject wishes by which he or she, by a statement or by a clear affirmative action, signifies agreement to the processing of personal data relating to him or her. And then recital 42 says, consent should not be regarded as freely given if the data subject has no genuine or free choice or is unable to refuse or withdraw consent without detriment. I still think that in this whole context, you could easily say the user has a choice. You can choose to use the app. You can install it on your phone or you cannot do it. If you have it installed, you can still turn off Bluetooth, because this worked with Bluetooth technology. When you are diagnosed as having COVID, you can still tell your doctor, I don't want this to be uploaded. And as the final part, you can also not notify your own code to the central backend servers and nothing will happen. So in my view, you could say consent, but again, I disagreed. The supervisory authority did not agree. In their view, this could not be consent because you cannot exclude the possibility that somebody is forced by, for instance, their employer. So another discussion about the concept of what is consent, what is freely given, what is a freely given unambiguous indication of the data subject's wishes. When can you say it's freely given? When can you not say that? And also here's some discussion in the newspaper. It's in Dutch, but I made a translation. The journalist asked the Data Protection Authority chair The state's attorney, and I have to admit, that's me, is quite critical about your advice. I did not agree with the supervisory authority at all. And he said that it was very inappropriate to be critical about the supervisory authority. All right, we go to the last example, and this is about data subject access rights. The right of an individual, we have it, we in the European Union in Article 15, you have it in Article 13 of your Data Protection Act, the right of an individual to have access to the data that is processed by a controller. And the controller needs to inform the data subject if any data is processed, and if so, what data, the purpose of the processing, the categories of personal data, the recipients, etc., etc. It's a long list of information that has to be provided. In your act, this is all put in Schedule 5. So many issues about this and a lot of litigation. For instance, data subjects sometimes expect to get a copy of their file. They do a data subject access request and they expect that the controller will give them a copy of their whole file. However, the Court of Justice, the highest court with respect to the GDPR and the predecessor of the GDPR, Directive 95/46, ruled in a case in 2014, actually it was a Dutch case, no copies of documents have to be provided. The data subject access rights only give the data subject the right to get an overview of the data processed. So it's not the complete file. It could be 1 or 2 pages that says, well, we have your name, we have your date of birth, we have this illness, we have your whatever, any type, but only a list of the data, not a complete copy of the document. However, in some instances, the lower courts in the EU, in the Netherlands said, yes, but if you don't provide a full copy, you don't give enough context. So we still have some debate about this, but the starting point is an overview is enough. You don't have to provide documents. What data, what not? Well, I've seen many data subject access requests where individuals asked IP addresses. I want to know, says the data subject, what IP address about me you have stored in your system. Well, and then it all comes down to, well, is this IP address personal data or not? Very complicated question. We have some EU case law about this. It's not easy at all. But very important to appreciate is that a data controller only has to provide the data he already has, which is in his system. The data subject access right does not give the individual the right that the data controller generates data, because that data is not there yet. Many cases about abuse of rights. We see individuals asking time and time over again the same data. Well, at some point the controller can say, well, this is enough. I provided you with the data. I will not take up a new request within the next 6 months. There are many exceptions. For instance, tax authorities may refuse to provide access because that would compromise their enforcement mechanism. Another issue, there's a lot of case law about that, is the specification of broad requests. Some data subjects ask big organizations, for instance, the Ministry of Justice, I want to have access to all my data. Well, courts tend to say, and the GDPR provides some support for that, that is too broad. You need to specify what data you will have. You name a period. I want the data in that specific month, or I want the data about that specific issue, or I want the data that the HR department has. But sometimes specification of the request is required. And the last issue is the verification of data subjects' identity. Of course, when a controller receives a data subject access request, he needs to verify the identity of the requesting individual, because you cannot provide the data to the wrong person. That would be a data breach. So you need to verify the identity of the data subject, and then it becomes really practical. A lot of municipalities, a lot of companies in the Netherlands say, you send me a copy of your passport or your ID card, and then I believe that it's really you, and I comply with the request. Our highest court, the Council of State, so the highest national court, approved of that. But there is a document from the European Data Protection Board, again, that body of 27 supervisory authorities, that says, yes, but copies of ID cards, copies of passports, that is very unsafe. But then the tension is, of course, okay, but what is the alternative? Well, you can ask people to come in person with their passport to the office of the municipality, but that might be a really big burden. So it's the tension between make it easy, user-friendly, copy of the identity card, copy of the passport, or choose for more safety, more security, asking individuals to come by with their card and show their face and their identity card, and then the request is dealt with, which creates a high burden for the data subject. Well, this is my short story. I'll stop sharing right now. And I guess, Sanduni, the floor is open for questions.
Thank you, Professor Svena, for this very comprehensive take on what's happening in a country like Netherlands, and especially how information generated by telecommunications sector, as well as which is also can be related to the tech services industry as well, in approaching these kind of topics in Sri Lanka once the PDPA comes into effect. I have a few follow-up questions to what you discussed during the keynote, and I'd like to invite the participants to put in their questions in the Q&A if you have any specific questions on what was discussed in the keynote. So, Professor Svena, you in your initial example, you spoke about defining personal data, and this is kind of a topic that has been coming up again and again about when, especially when you're even responding to data subjects requests, when deciding which data to disclose and which data to be withheld. And so one of the issues that affects stakeholders in the wake of any new regulation in personal data protection, like we've seen how the GDPR was perceived in 2018, and right now in Sri Lanka with the coming of the PDPA, there's certain confusion in determining what constitutes personal data. And amidst such confusion and a rush to be compliant, some stakeholders tend to adopt a rather broad definition when it comes to personal data. And so I'd like to pick your brains on what are the dangers in trying to include anything and everything within the definition of personal data. So does it include IP addresses? Does personal data amounts to metadata, location data, etc.? And as personal data, and just such measure like trying to include anything and everything within the definition of personal data would actually lead to more effective protection of personal rights or the rights of data subjects to the public. What are your thoughts on that?
Yeah, it's a well-known issue, and I'm sorry to say, but we have not resolved it yet in the EU. We're getting there, but as my first example showed, with the location data used to monitor the development and the trends with respect to the pandemic, in the end, it stopped the whole initiative. And it's really hard to make solid statements about that. But I am pretty sure that as a result, lockdowns lasted longer than perhaps necessary. And when you're talking about fundamental rights and freedoms, of course, data protection and privacy is really important. I fully recognize that. But if the implication is that the lockdown lasts 2 weeks longer, that's also an enormous infringement of personal rights, of fundamental rights, because people cannot get out of their houses. People cannot go to work. The whole economy is closed down. So the Court of Justice has said many times, for instance, in the last right to be forgotten judgments, that privacy is not an absolute right. You need to balance it against other rights. And also, when you qualify specific data as personal data, you make a choice. Some things can and some things cannot. I'm not at all happy with a too broad definition of personal data. I think it should be practical in the end. IP addresses can be personal data. For instance, for a telecoms provider that assigns an IP address to me, it is personal data because he knows the subscriber. I am the subscriber. He knows my identity. So the IP address that was assigned to me by my telecom provider is personal data. However, when I'm using free Wi-Fi in the train or in a Starbucks cafe, I think it's impossible to identify the user. There might be 100 users in that train using that IP address. So in that context, it is not personal data. I hope I more or less answered your question, but I'm not sure.
I think it revolves on the question about how determination of whether something is personal data or not, or whether something is private or not, it always depends on the context of application. So
it depends on the means that the controller has to identify that individual. And if you give me an IP address, well, I'm a simple law professor, I will not be able to identify the user. However, in the context of a telecoms provider, they may be able to identify that specific subscriber, and then it's personal data. So not at Starbucks, yes, at the telecoms provider. And you have to be very nuanced about that, but this is how you can deal with it. And this is also what the Court of Justice in the Breyer decision said, 2016, and it was confirmed, I think, a year ago in the Mirfcom decision. If the audience likes that, I can easily send them the sources of these court decisions.
that would be great. And just to follow up on that, Roswena, so when you speak about some data, it's contextual and some it may not be. And do you think from a protection perspective, it grants more rights to data subjects when the definition of personal data can be contextual? And wouldn't it create a certain level of uncertainty even for controllers when they're trying to determine whether something is personal data and something is not? How would you address that kind of concern?
Yeah, that is a real concern. And again, this is something we have not resolved yet over here. In 30 years of working with data protection, this is a continuous issue. What really helps is, of course, a court of justice, a Supreme Court decision that sets some guidelines on that. Also, supervisory authorities can be really helpful here. And this is what I personally feel frustrated about, that our current Dutch data protection supervisor tends to deviate from court decisions, case laws, and also what other supervisory authorities in other member states, with, mind you, exactly the same rules. It's the same regulation. But that's, for me, that's a bit frustrating because it stops important initiatives. It results in some kind of data protection panic, which we really don't need right now. We need to be practical about these things. What you want is guidance by the lawmaker, legislature, by the courts, and by supervisory authorities.
Thank you, Professor. And I think that's a very good observation to be made, and it's something Sri Lankan, the future DPA, can also learn from as it comes about. And just to focus the discussion a little bit about consent, because we spoke, I mean, in your keynote, you spoke extensively about it. And it is sometimes argued that consent is losing its vigor as a lawful basis for processing, because informed consent is often difficult to establish in most cases. Because even you spoke about, giving free choice. I mean, does it involve just having alternative options, or is there more to defining what is informed and free consent? And do you think such concern is valid? And should regulators and controllers look beyond the mere notion of consent in future data protection policies, whilst maintaining transparency and accountability in their processing activities?
Yeah, consent is one important basis, but it's not useful in every context. For instance, in an employer-employee context, we do not like using consent because there's a hierarchy, and in the end the employee has to do what the employer tells him to do. So in that context, there will always be doubts about, is this consent freely given? There are exceptions, but as a general rule, employers should not use consent to process data of their employees. There it should be execution of the contract or legitimate interest or perhaps a legal obligation. There are many other processing grounds, basis for processing, and here consent is not the best one. Also, government vis-a-vis citizens probably should not use consent too much because, well, if you need a driver's license, there's only one institute where you can get it, and that's the government. At least in my country, that's the government. So they cannot process my basis on the basis of consent because I need a driver's license. I cannot live a normal life without a driver's license or a passport. It's the same thing. So in that context, don't use consent. But with the contact tracing app, we had privacy by design, many safeguards. There was no obligation to have the app. You could choose to have the app. You could choose to set it on or off. You could turn Bluetooth off. You could tell your doctor, I will not give you the code. And then the doctor would say, well, that's fine, no problem. You could even choose when you gave it to the doctor not to validate the code yourself. So there were like 5, 6, 8 options to say yes or no. So in my view, that is consent. We had privacy by design, this is consent. But here, again, I disagreed with the supervisory authority on this. For them, the issue was, yes, you can remove your data from the backend server. You send a message, please remove my data, and then they remove it. But you cannot send a message to all the other individuals that have your code. And for that reason, they said it's not freely given consent. I completely disagree, but I'm pretty sure you will have, like we have, many discussions about, is it informed consent? Is it freely given consent? There's also something like granular consent. Yeah? You ask consent for 5 items, and then you have to provide the user, the data subject, the option to agree to this, not agree to this, agree to this, not agree to this. You'll have discussions about that, I'm pretty sure. And that's normal. And in a way, this is what makes data protection law interesting. So be happy.
It certainly does. So I'd like to take a question from the audience. So there was one question about the recent move by Sri Lankan shops, which asked to provide an email address to provide e-bills. Just to give you context, there's a paper shortage currently the Sri Lankan market is facing. So most supermarkets request us to, customers to provide their email address in order to email the bill for them. So then the question is, so providing an email address affects one's privacy and security of information. So what can be done as actions as the subjects in order to prevent that sort of request? Object to that sort of request?
Well, here, from a legal perspective, apparently the email address is needed for the execution of the contract, the performance of the contract. So in that, I don't see a real issue, but I do see the issue. It is personal data. Perhaps you don't want to provide it because it will result in a lot of spam. Solutions are from a technical nature. In my iPhone, Apple provides the option that they generate an email address, and when I get too much spam, I just delete that email address and it will not get the spam anymore. Still, at the same time, I assume that when you have a contractual relationship with a provider and it continues, well, you need to have a permanent email address. You cannot use a one-time email address, what could be a solution for a one-time transaction, but a continuous email address. Then you need to have rules for spam, for electronic marketing. And in the EU, this is dealt with by these electronic communications directives. And basically it says you can only send unsolicited messages if somebody consents to that, unless there is already a contractual relationship, but then you need to provide an opt-out, like the unsubscribe option.
I think that's a very valid point to take, and I think that there is provisions in the PDPA as well to regulate the use of unsolicited communication. And maybe once the act is in full force and effect, maybe something that the subject would rely on if the service providers use this, process this information for any other purpose. So in the interest of time, brings me to my last question to you. So a criticism that is often leveled against personal data protection regimes or laws by the tech and telco sector is that lawmakers attempt at regulating automated decision making and the use of technologies like AI, artificial intelligence, in processing personal data. So how would you reconcile Article 22 of the GDPR with the sweeping regulations under the upcoming EU AI Act? And what kind of global effect or rippling effect would you anticipate, especially in relation to companies or establishments located outside the EU and who provide services to the EU market? So because I assume there are few members of the audience who represent these kind of organizations.
If services are provided to data subjects in the EU, the GDPR applies. So that's, you could be in India, you could be in the United States, you could be in well, whatever other country. But if services are provided to individuals in the EU, it doesn't even have to be citizens. It could also be asylum seekers with no title whatsoever, but they are data subjects in the EU. So then GDPR applies, and then Article 22, which is on automated decision making and profiling, has some restrictions. For one thing, the automated decision making needs to be solely automated, so no human intervention whatsoever. That's one. The other one is it needs to have a legal effect or serious effects. And with respect to advertisements, you could ask the question, does that have a serious effect? It has no legal effect. An advertisement has no legal effect, but a banner, does it have serious effects? Where I'm in doubt is the filter bubbles. If you can use algorithms to push somebody in this rabbit hole of conspiracy theories and right-wing or left-wing, what have you, political orientation, I would be inclined to say, that has a serious effect. If you can influence elections, like assumingly was done with Brexit or with the election of Mr. Trump, then I'd say that has a serious effect. But still then, there are some exceptions to this rule. So my answer to this, and it's not a full answer, I fully recognize that, but I feel I'm an expert on GDPR and not yet on the AI regulation, which is not enforced yet, which is not adopted yet. So I don't even know the full text right now. But in terms of GDPR, there are some steps to be taken. Not every algorithm will fall under the scope of Article 22, but perhaps some will. And well, unfortunately, this is more or less the answer I can give right now, because I didn't study, and I did some cases on automatic decision making, but these were all dealt with not on the basis of the GDPR, but on the European Convention on Human Rights, Article 8, which is a bit difficult. So.
Thank you, Professor Bannon. I think there's one last question. I'm not exactly sure what the intention behind exactly, but the question is, how far behind would you say the current Data Protection Act in Sri Lanka is when it compared to the GDPR? I assume this means in terms of the timelines or content. If you have any initial thoughts, brief thoughts on.
Yeah, well, behind suggests that it's a race, and I'm not sure. Sorry, my wife wants to go to dinner with me, to lunch. All right. So behind suggests that that's like a race, and I don't feel that you should see it like that. Sri Lanka has its own context and its own perceptions and expectations with respect to privacy. So I'm really not comfortable in saying that GDPR is in front and you are behind. Perhaps you are in front of us. I don't know. What I saw in your Data Protection Act, that you put a lot of things in schedules, in attachments, Schedule 1, 5, etc. And that might be a very sensible solution to deal with a fast-changing environment. And in that sense, I'd say, well, perhaps you are way ahead of us. Of course, with the GDPR, we have the problem. It's for the whole of the EU. So it's 27 member states, and they all have their own opinion. So everybody wants their own little exception in it. So that makes it a really big compromise. So I'm not inclined to say that GDPR is perfect. It's probably the best we can do right now in the EU, but it's not perfect. And perhaps in Sri Lanka, you made something far better. Possibly, or the other thing is, it's for your country and you have a different culture, a different system, different mentality, different expectations. So no, not behind. You have a different concept. It looks a lot like our GDPR, which for me is nice, but doesn't make it better. I'm sorry, I have to quit here right now, because I can answer any other question by email if you want, Sanduni.
Thank you, Professor Swan. I think that's all the time we have also allocated for the discussion. And I just want to thank you on behalf of the Ceylon Chamber of Commerce for accepting our invite and joining us and providing us a very comprehensive overview of the data protection regimes and how it applies to telco and tech sector. So thank you again, and great having you here.
Bye. Thank you.
Bye. So we have, I'd like to take a break for 15 minutes, and we'll join you back again at 4:15 Sri Lankan time for the panel discussion. Thank you. Welcome back, everyone. I hope I'm audible. So in the next 1.5 hours, we will be joined by a panel of experts in their respective fields to discuss about the implications of data protection regimes in the telecommunications and technology services industry. And joining me on this panel is Mr. Jonathan Fernando, who needs no introduction. Of course, you all know him very well. He's a general counsel for Information Communication Technology Agency here in Sri Lanka. He also served as the chairman for the drafting committee of the Personal Data Protection Act. And Jonathan accounts for over 20 years of international experience in a range of ICT and legal policy issues. He has specialized master's degree in telecommunications and ICT and internet law from Queen Mary University of London. And he has pioneered drafting several legislation impacting digital transformation, including the Electronic Transactions Act, of course, the Personal Data Protection Act, digital and mobile payments, cybercrime, cybersecurity in Sri Lanka. He gave leadership to Sri Lanka's entry to the Budapest Convention, Budapest Cybercrime Convention in 2015, making Sri Lanka the first South Asian country to accede to the Cybercrime Convention and also the UN Electronic Communications Convention, both are first for South Asia, including the PDPA, where Sri Lanka became the first country in the South Asian region to enact a very comprehensive Data Protection Act. And we are glad to have Ms. Raina Young, who is the head of Privacy and Data Policy Engagement, APAC for Meta Incorporated. She's a lawyer by training and is a former regulator, having previously worked at the Hong Kong Privacy Commissioner for Personal Data in the position of Assistant Privacy Commissioner, Legal Policy and Research. Prior to joining the Hong Kong Data Protection Authority, Raina had extensive legal in-house experience and held management position in both Hong Kong and Shanghai. She served as the Assistant Chief Counsel, Head of Legal at Hong Kong Disneyland, and was the Deputy Chief Counsel, Head of Legal at Shanghai Disney Resort during the initial construction stage of the project, where she helped set up the legal function at Shanghai Disney Resort. Raina also holds a Bachelor of Laws Honours degree from University of Melbourne, Australia, and she joins us today from Hong Kong. Hi, Raina. And next we have Sonali Vikramaratne. She's currently the Global Head of Internal Audit for Virtusa, and is a career auditor with 18 years of experience from renowned public corporations in the US, India, and Sri Lanka. She's also well experienced in working with CXOs for 11 plus years and US board member for 6 years. She has wide experience with audit, risk management, and compliance program management for US-based public companies. Through her corporate experience, she understands the complex correlations between board expectations, corporate objectives, regulatory alignment, operational efficiencies, and risks, which are often missed by those with singular view. And Sonali holds a BSc in Information Security and Decision Sciences with a minor in Internal Audit from Louisiana State University from the USA. And she's also a certified internal auditor, certified information systems auditor, and a certified information privacy professional. Welcome, Sonali. And last but not least, we have Shenuka Jayala, who currently functions as manager, regulatory group legal and regulatory at Dialogue Asiata PLC. She's an attorney at law who holds a Bachelor of Laws from University of London and a Master's of Law in International Business from University of West London. She's also a member of the International Association of Privacy Professionals and a certified information privacy manager. Shenuka also served as a member in the Personal Data Protection Law Drafting Committee that was engaged in drafting Sri Lanka's first ever personal data protection law. So welcome, everyone. And so just to start off this discussion, I'd like to invite Mr. Jonathan Fernando to give his initial remarks on the intersect between privacy and data protection laws in Sri Lanka and how it affects the tech and telco industry. Over to you, Mr. Fernando.
Hi, Sadhuni, and once again, nice to see Sadhuni and Raina our old friends Sonali and Shenuka on this forum. I'm joining remotely from not too far away, but thanks to good connectivity, I think you can hear me. Again, I just want to thank the Ceylon Chamber for being very proactive in their effort, not only to contribute actively in the drafting, engaging us in the drafting process, but helping to build awareness amongst key stakeholders in a series of events, and this one being specifically targeted towards the telco and the tech sector. I'm just being able to put some slides together, but maybe I'll just share it. Hope this comes through. Can the slides be seen? Good. Slides are visible, right? So in the interest of time, I will again reiterate a few points, Sandrine, that you made on the background and the process. It was discussed previously. For those who were not present last time, we just want to emphasize the significance. We all know the importance of this act. It was under discussion for some time, but the real mandate to draft this bill came through after a stakeholder discussion that took place in September 2018. Central Bank as well as SEC was in the forefront of that stakeholder discussion. And the drafting mandate was given to us in February 2019. So just want to give the background and context. We don't have a constitutional right to privacy. However, we need to be mindful that we have a provision governing right to information, under which there are exemptions. One exemption is right to privacy, and such are the legal frameworks provided by written law that imposes restrictions. So privacy safeguard has been recognized constitutionally in the context of Article 14A of the Constitution. In terms of legislative precedents that was looked at, we heard the learned professor mentioning the similarities and resemblance of our legislation to GDPR and other standards. GDPR was not the only one looked at by us in the formulation. We all know the OECD privacy guidelines being a baseline, a foundational step to many international standards. Convention 108, the only convention, international law instrument on the subject, emanating from the Council of Europe, the Data Protection Convention, was another instrument we looked at, APAC, together with the APAC privacy framework. Other country legislations were also looked at from, to ensure that we are compliant with international norms and standards. I mentioned some of them, most notably in the context of what our professor mentioned today in the context of location data, traffic data. It's interesting to emphasize that in the formulation of our legislation, certain principles such as those coming from Article 14 of the second additional protocol to the Budapest Convention that was finalized in 2021 was looked at in somewhat detail, and some of the safeguards contained in that were built into our act, which we can address more in greater detail during Q&A. I just want to emphasize that in the context of Sri Lanka being mentioned as one country that acceded and became a state party to the Budapest Cybercrime Convention in 2015, there are additional tools that were developed through negotiations between the parties to the convention, which includes US, Australia, Japan, and many European countries and many Latin American countries. Not to mention that there are quite a few African countries also involved. They were all involved in the discussion around the second additional protocol that was negotiated over a 4-year period. One particular aspect is cross-border access directly by a country in respect of a service provider located in another country. And the direct disclosure provisions in the second additional protocol is subject to certain safeguards, especially privacy. And in the context of the telecommunications directive and the EU directives that were mentioned by the previous speaker, it's noteworthy to take cognizance of these provisions, and that Sri Lanka has included those similar measures in our law. The fact that we had a variety of stakeholder discussions was mentioned during the introduction. I will not go into that. To emphasize again and re-emphasize the preamble to the Data Protection Act that brings out the fact that this is a law to facilitate growth and innovation in the digital economy while providing safeguards and to improve interoperability amongst data protection frameworks and strengthen cross-border cooperation amongst enforcement authorities. One facet is, of course, regulation of personal data and processing thereof, which we will touch on briefly in the context of telecom and the tech sector, and of course to identify and strengthen the right of data subjects. In terms of date of operation, we have given a grace period, but it's important to understand and emphasize the need to set up a data protection authority before the law is brought into operation. And I need to re-emphasize that in every fora, because authorities should take a note of the importance of setting up a data protection authority. Best efforts were done in terms of drafting the law, but it's up to the policymakers to set up the data protection authority. So the definition of personal data is well known. It's there in the Act. The parameters and boundaries, unique identifiers that identify an individual, and there's a separate definition for special categories of data, which we can go into later. The law is, and the remedies available under the law is broad in the sense that it applies to data subjects, individuals, natural persons like you and me, not to companies and other entities. And of course, we must understand that the law does not restrict the availability of remedies to citizens. It's available to all persons. Controller processor definition is something to note in terms of who is a controller and a processor. I'll come up with some real examples. In the context of the telco tech sector, what's important to understand is that bank onboarding customers, telecom providers onboarding customers, they will become deemed controllers under the Act, having to fulfill obligations that other speakers will go into in more detail. And in the context of government entities such as the Identity Office, Immigration Department, that will take on our information, our personal data, and process them under their respective laws, resulting in an output such as a passport or an identity card. Such entities engaging private sector tech companies and telco providers to facilitate products and services should be mindful that they will be performing the role of a processor. And in the context of some of the tech companies developing products and designing them, they may become joint controllers as well. So in that context, it is noteworthy of the additional obligations emanating from Section 22 of the Data Protection Act. We can go into those details later, but more importantly, the obligation on controllers to do a data protection impact assessment under Section 24, where various parties would have a role. One example we can give in recent times is what happened in the context of the fuel pass, which was a public-private partnership in collaboration with the private sector providers. And while the government entity responsible or the ministry responsible may be the controller, the private sector partners would play the role of a processor, requiring them to do take on obligations under the Data Protection Act. So I'm not going into all of the details contained in the various provisions in the Data Protection Bill or the Act, but more notably emphasize Part 3 and flag the provisions that I have highlighted in red here, the need to fulfill those obligations arising from Part 3 of the Act. In terms of cross-border data flows, one noteworthy factor to keep in mind that will impact telcos and tech providers who provide services to government entities is the requirement for localization. However, if there is a requirement for a number of reasons to host data outside the country, there is a way of doing it in conjunction with the supervisory authorities to classify and categorize the various data sets. And of course, the future Data Protection Authority would have a role to play there. However, we should note that Sri Lankan private sector entities have much greater freedom when it comes to cross-border data flows, especially the flexibility under 26(5), which I thought we should note. Finally, of course, we should be mindful of the sanction provision, the remedies available. This act should be regarded as a soft law instrument for the reason that no criminal penalties are imposed. What is imposed are penalties, administrative fines, but that also is done only after directives being issued after hearing all sides to a particular issue or a violation, and a directive is given to a controller or processor to do course corrections. So it is thereafter, if there's a further violation, that it would entail penalties, and we should keep note of that. And there are mitigation factors that a regulator has to ensure that it follows, which are described in Section 39. So I will not go into details of that, but suffice it to say that we should take cognizance of some of these key provisions when we look at the application of the Data Protection Act to the telco and the tech sector. Thank you, Sandhani.
Thanks, Jonathan, for that initial remarks. So I will circle back to you on some of the follow-up questions I have on what you mentioned. And I'd like to next move to Ms. Reina Young. So I'd like you to share your initial views on, I mean, as a privacy professional in a social media platform like Meta, as well as your experience as a privacy commissioner in Hong Kong. What are your initial thoughts on the implications of a data protection regime in the telco and tech sector?
Thank you, Sandhani, and thank you to the Ceylon Chamber of Commerce, and thanks for having me today. I'm honored to be joining this panel with distinguished speakers, and I've learned a lot from listening to Professor and from Jenter, and hope to contribute to the discussion and learn from my fellow speakers and from you all today. So since the EU passed the GDPR in 2016, it has brought privacy and data protection into the mainstream. And based on the figures released by the United Nations Conference on Trade and Development, as of December 14 last year, 71% of the countries in the world had data protection or privacy regulation, and 9% had draft legislation. And the statistics shows that more and more countries are recognizing the importance of protecting privacy and for individuals and also for the society as a whole. And I congratulate the Sri Lanka government in like the majority of the countries, they adopt the first the comprehensive data protection law, and is the first country among the South Asia to pass a comprehensive data protection law. So now Sri Lanka has a data protection law. So what is this about? In June 2019, the then European Commissioner for Justice, Consumers and Gender Equality, Commissioner Jourova, she was reviewing the impact of GDPR after 1 year when GDPR became effective. And in one of the speech that she delivered, she unpacked the meaning of data protection. So according to her, the application of GDPR showed that data protection is really about sound data management. It's mainly about having a culture of responsible use of data, putting in place operational rules for those at all levels dealing with the data, and ensuring appropriate data security. So data protection law is not just about a checklist. It's about building a culture of responsible use of data. So I'm going to share with you on Meta's journey to building a culture of responsible data use. So for Meta, we've spent the last few years designing, building, and improving our privacy program. So today, our privacy program framework closely resembles the leading accountability models, such as the foundational work that the Center for Information Policy Leadership has led on accountability world. The most critical foundational element of an accountability framework is leadership oversight, or tone from the top. So we are at a place in Meta where the importance, investment and accountability that leadership places on privacy is clear inside the company. So privacy has become consistently a top company priority and one of our top investment areas. So we have thousands of people that are working on privacy every day at Meta now. And our work on privacy also continues to be a board level priority. So we regularly report to the privacy committee of the board of directors on our progress. So within Meta's board of directors, we have an independent privacy committee, which is made up of independent directors with a wealth of experience serving in similar oversight roles. And it meets quarterly to ensure we live up to our privacy commitments. Our leadership, including our CEO, Mark Zuckerberg, he has a high degree of feels a high degree of accountability with respect to certifications that he personally makes every quarter, but also with the product decisions that we make every day. So ultimately, Mark is the escalation point for the decisions and issues that come up during our product development process. And not only is privacy a focus for products that we're building today, as we think about the future of technology, our leadership is also emphasizing the importance of privacy. So Nick Clegg, who is our president of global affairs, recently published an op-ed highlighting privacy as a key priority of how we build towards the metaverse. And privacy is everyone's responsibility and matter, from our CEO and executives to engineers and sales team across the globe. And everyone across the company, we are all responsible for privacy. So as a result, we have a cross-functional group of stakeholders across the company who provide engineering, legal, policy, compliance, and product expertise that enable the design and implementation of our privacy program. So through our privacy program, we've changed the process by which we onboard every new employee at Meta to make sure that they think about the role through a privacy lens and design products and services with privacy in mind from the beginning, and work proactively to identify privacy risks so that mitigations can be implemented. And we also require all employees to complete annual privacy training. So we regularly drive awareness and engagement through internal campaigns like Privacy Week. And we create dozens of teams, both technical and non-technical, that are focused solely on privacy. And they're being led by two different chief privacy officers, Michelle Prudy, who is our chief privacy officer of product, and Aaron Egan, who is our chief privacy officer of policy. And we also have an internal audit team that brings independent assurance on the overall health of our privacy program and the supporting control framework. And process-wise, we have set up a privacy review process that's conducted by a cross-functional team that comprises of lawyers, engineers, and policy people, etc. So this privacy review process is central part of developing new and updated products and services that matter. So through this process, we assess how data will be used and protected as part of a new or updated products and services. So we work to identify privacy risks that involve the collection, use or sharing of personal data and develop mitigations for those risks. The goal of the process is to maximize the benefits of our products and services for our community, while also working upfront to identify and reduce any risks. And if there is no agreement between the members of the cross-functional team on what needs to happen, the team escalates it to a central leadership review and further to mark our CEO if needed for resolution. So good data governance and having a good accountability framework is critical to ensure that people can trust that their data will be protected. However, we believe that accountability doesn't just mean building robust internal systems, but also being accountable externally, including being transparent about our efforts. So there are 3 examples of work over the past year that demonstrates our transparency investments. The first is our investment in transparency and understanding of our data practices. We update our privacy policy recently. And in 2020, we wrote a white paper on the importance of people-centric design to make data and privacy easier to understand. So following the release of the white paper in 2020, we kicked off a global series of consultations to get feedback on how to make our own privacy policies more useful for people who use our products. As a result of the feedback that we receive from privacy experts, policymakers, and people that use our services every day, we made updates to our privacy policy. So now it's more readable, more transparent about our data practices, and we use easier to understand language and real-world examples, and it also contains several informational videos. And critically, we pair the updated policy with control so people can make informed decisions when they're reading our privacy policy. It doesn't change our privacy practices or how we collect or use or share our data, but it makes our policy more transparent and easy to understand. The second example is driving transparency in the work that we're doing internally on privacy and matter, and the progress and investments that we're making to continue to improve our accountability framework and approach. So last year, we launched Privacy Progress Update, which is a website that details the investments that we made in our privacy program and highlights some of the outcomes that the work and the product decisions that we made. So this year, we also update this site with additional improvements we've made, including some that I just mentioned earlier. So we plan to continue to update this site on a regular basis to help bring people along our journey. And the last example is our launch of a privacy center this year. So the Privacy Center is an online hub for educating people about our privacy practices and controls across the Facebook, IG, and Messenger apps. So in the Privacy Center, people can learn about our approach to privacy. They can read about our privacy policy and learn how to use many privacy and security controls that we offer. We'll continue to update our Privacy Center and add more modules and controls to help people understand our approach to privacy across our apps and technologies. So I hope our experience on building privacy will provide some useful pointers to you and when you're considering to build your compliance program. So thank you for listening, and I'll turn the time now over to Sanduni. Thank you.
Thanks, Raina. Thank you for those illustrations about how Meta is building its transparency and accountability framework. So we'll revert back to that in a little bit. And for now, I'd like to open the floor to Sonali to speak, give us some insights as to your take on how data protection regimes impact this particular sector.
Thank you, Sandhini. Thank you for the introduction and the opportunity to speak today. And also very happy to meet the panelists today. as well as all the participants. Welcome to all. I have one slide which I will use as an agenda and a guide for my discussion today. And my focus is actually tying some of the privacy concepts a little better into the technology industry. Raina did a fabulous job in making a backdrop into what I was going to say as well. There will definitely be parallels, but I will focus it on more on the technology industry a little bit more as I run through this. So let me flash my screen here. Can you see? Are you able to see? You are? Okay. All right. So I'm just going to start off by asking the question, why is privacy a necessity in this technology industry? The answer is really simple. It's credibility and brand value. You can't be a credible global player without privacy in the modern day. Privacy, as Raina also touched upon this, represents both humanity and responsibility, which contributes to your brand value. If you're in the tech industry, more than likely you have clients or partners in the international space who are tightly regulated by their national laws. So if you want to be a best of class international tech partner and attract business, then privacy is one of the key areas that will tie into your credibility and strategy, along with your competitive skills and cybersecurity posture. They actually go hand in hand, particularly if you want to expand your client base into like international government sectors, financial services, aerospace, healthcare. Privacy is your first step to enter this space. Without privacy, your expansion in the international market will be impossible. So again, coming back to the simple question in the technology industry, why is privacy a necessity? It's to establish your credibility and brand value and to become a good international player. Now, as we take this privacy journey, right, going into the second part and particularly focusing on Sri Lanka, what is that weakest link you have to overcome to establish this structure? The answer is it's your people, both inside the company and outside the company, right? So as Sri Lankans, we are naturally very inquisitive. We are a little lax about sustaining our privacy. On top of that, we also have somewhat of a struggling economy where our main focus is on our fundamental needs of survival. So in this particular kind of a socioeconomic backdrop, how do you make privacy a key focus or make it matter to your people? There is one way of considering making this psychological shift to value privacy. And I believe the very first step is to put the fear in them, to understand and help them understand what happens if your identity or your personally identifiable information is lost. A lot of people actually don't know what happens when it's lost, and that's why they don't seem to care. So a lot of things, as many in this forum know, a lot of things can happen, right? People who steal your information can access your bank accounts, assume ownership to your property, access financial aid in your name, and even worse, they can impersonate you and your identity can be utilized to smuggle prisoners or drug lords who are inmates out of prison. So your identity can travel far and wide. The loss is not limited to the space of Sri Lanka, and that's the message that we need to get out there. I recently had a data exposure with a local bank. When I was speaking to the assistant manager, I was stunned to understand that she did not know what happens to the lost data, nor did she know that it can leave the boundaries of Sri Lanka. So we need to change that mindset, right? There has to be a national focus on helping people understand what happens to their lost information so that they can start caring. Each tech company cannot start this by their own in shifting this psychology. There has to be kind of a joint initiative between the tech company, whether it starts with Glasscom or wherever it is, where tech companies take the responsibility of addressing this issue with the public of what happens, because it is from that public pool we take our employees for employment. So the more you educate them, whether at a student level or at public level, you're preparing for a stronger workforce to work for you, and you're addressing that weakest link. So that is about getting past that weakest link in Sri Lanka. Now, once you get past your weakest link, what are the first 3 things you would do in the light of a new privacy law to prep your company? Raina touched upon a lot of good points. I'm just going to focus on 3 minor tasks just to get your foot in the door here. One is study the privacy landscape of your company. Your first step is to identify the component of human data that the company deals with, right? Because each company is different and each component of data is very different. So knowledge is power, and it's extremely important to understand what is the exposure I have as a company to my employee data, to my client data, and any other human data that you process. So your first step is gauge the exposure, because privacy is a costly affair. It's not cheap by any means. So you need to understand what is that investment that will give you a good return as a tech company. What is that investment you need to marry into your brand value? So know your exposure, because the exposure will also facilitate the talks that you will need at a later stage, so that you start with a point of knowledge. Your next point is to gauge the points in your business where you actually deal with the data. That is where you collect the data, where you process the data, where you retain the data, and where you release the data. This is your first data mapping exercise. Again, awareness and knowledge, right? And there has to be purposeful data collection. Don't collect personally identifiable data for the sake of doing so. Again, it increases your risk and it increases your cost, right? So ensure that you know what all of these points are. And your third point in prepping up your privacy program is, where do you store the data? Oftentimes in a very nascent program, what happens is you find name in one place, age in one place, address in another place. It's all distributed, and that's not efficient. And then you cannot focus your privacy efforts in the right places at the right time. So it's very important for you to understand where are you storing the data, so that you can consider whether over a period of time you can centralize it. And another small point I want to bring here is, when it comes to security and retention of your data, privacy goes one step further. Now, in general security, we lock access, saying read-only access for a group of people, because read-only means you can't do anything with data. But privacy is different. What you see is what you get. So even the people who access your databases have to be strongly restricted, so that it fits their job responsibility and what they do, and nothing more, because what you see can be utilized for anything else later, right? So those are the 3 very fundamental rudimentary steps to kick off a data privacy program, right? Now, once you actually start and you mature, what can you do to gain that credibility in the marketplace with your clients, your market, whoever you deal with, your partners, right? So I'm going to bring you some points which I acclaim as the journey to credibility, which came across from one of my previous experiences. I worked for a company called ChoicePoint once upon a time, which had a huge data breach in 2004, around 2004, where 163,000 consumer records were lost, and they had to pay 15 million in penalties to the FTC, 10 million in civil, 5 million in consumer redress. ChoicePoint was also the largest human data warehouse at the time for the US. Now, we had to do a lot of work to get the credibility with the regulator all over again. And what I'm saying here is to go ahead and build this credibility into your program from day one, once you get past the nascent stage. Starting with accountability, and Raina beautifully pointed this out as well. The first step is there has to be someone accountable in the company for your data privacy. People cannot go from one place to the other, whether it's the regulator, whether it's the data controller, whoever it is, but there has to be well-accounted parties at different levels, whether it's at the board level, whether it's at the senior management level, at a program level. Accountability has to be crystal clear. There has to be a policy that clearly represents the principles of the company when it comes to privacy. It has to be accessible, it has to be updated. It also has to be on the website of the company, because if you're a tech player, people need to know what you're doing out there, right? You have to have a credible control framework to benchmark your privacy program. And I can't stress this enough. It's because if you are not utilizing a framework, what happens is you may miss certain risks and controls that are necessary to fortify your system. And by meaning credible also, it has to be an internationally accepted framework. What we utilized in ChoicePoint was ISO 27002. Now it's ISO 27002-2022, which focuses on information security, privacy, and cybersecurity, which gives you an in-depth guidance on what needs to be covered. Routine reviews, right? Again, coming back to brand value. You need to have someone credible looking at this well-structured privacy program. So you can have internal audit look at it, or you can have an external partner look at it. It depends on the space that you actually play your field. So if you're a player in the international industry, I would say get a well-accredited audit partner like the Big Fours, the KPMGs, the Deloitte, the PwCs, EY, any of those, because your brand is tied to those who actually confirm the credibility of your program. And there is a brand value that comes from those partners as well. And so routine reviews and getting a credible partner to do that is important. Now, if you're not having a lot of global clients, perhaps you can rely on internal audit. But if you have large clients out there, let's say Google is a client, Apple is a client, and so forth, I would say match those brand values to the partners you select for your routine reviews. Finally, consistent training. This is an incredibly important part in your program because there's always attrition, turnover, you have different people coming in and going. So the consistency is important, and the technique of training is also important when it comes to privacy in a country like Sri Lanka. You can't have this web-based training, which is really boring, and you have this bunch of text and multiple choice questions, and you're saying, hey, we did privacy training. No one's going to benefit from it. You're not going to benefit from it either. The best ways to do privacy training is actually role-based video training or skit-based training, where people actually see like a little skit or a little teledrama kind of thing, where it actually goes into their psyche. Or gaming. Gaming is another good technology where you game to get a concept into your head and you're brainwashed. So it's better to utilize something that actually changes the way people think than to do that web portal boring training. But the consistency is also very important. So that's just the points for the tech industry to consider, or even if you're not in the tech industry. I hope this was helpful, and I thank everyone for listening and for giving me this opportunity to speak. Over to you, Sandini.
Thank you, Sonali, for those very valuable points. And we'll discuss more of that in detail when it comes to the Q&A. And next, I'd like to move on to Shenuka, who represents mostly the telco industry in this panel, and to share her initial views on how the PDPA and other regional laws impact the sector. Over to you, Shanika.
Thanks, Alani.
Sorry, Sandhini, I need to take this down, I think, just a moment.
Please.
Do you still see my screen?
Yes.
Okay. Okay, is it away now?
Yes. It's fine.
Thank you, sorry about that.
Just give me a second to share my screen. Can everyone see? It's something you can see. Yeah. Okay. So I'll quickly take everyone through the current data protection frameworks applicable to the telco industry. That is, this is pre the Act. So as the Act isn't operational yet. So this is basically what applies to the telco industry. It's mainly the license that you are issued with under Section 17 of the Telco Act, which has one license condition on privacy and confidentiality. So we are supposed to take reasonable steps to safeguard the privacy and confidentiality of any telecommunication network. And we're supposed to use our customer data only with the consent of our customers for the purpose of providing the services under the Act. Then you're not supposed to disclose any of the information of the customer without the customer's consent. And there are certain exceptions which are inbuilt into that condition where you are allowed to share personal data or customer data with the TRC, that is the Telecommunications Regulatory Commission of Sri Lanka, which is the regulatory body regulating all telecommunication service providers in Sri Lanka. And you're allowed to share with the TRC, you're allowed to share with security agencies, law enforcement agencies for prevention or detection of crime. And if you need to work with other operators to investigate fraud, for example, you are allowed to share for those purposes. So there are actually very strict practices already in place within the sector in terms of sharing of personal data because of this license condition, which mandates that you do that. So if you take, for example, even sharing of customer data with law enforcement agencies, it's not something that we would just simply do or just over the counter. Anyone who comes, you need to come with a court order, and you need to come through the relevant channels of the law enforcement. So it's only once the request is channeled through the correct means that we would facilitate the request. We wouldn't just, no one can walk in and simply ask for the data. So and there are, of course, regulations that are put out by the regulator on a periodic basis with regard to the data you're supposed to collect and how you can send out messages, etc. So that's just a very, very quick, in a nutshell, overview of what it is today. And the introduction of the law, it actually it supplements these efforts to a large extent, and it makes you more accountable for your actions using personal data. And all telecommunication service providers would be deemed controllers under this law, and therefore subject to the host of obligations that are placed on a controller of personal data under the Personal Data Protection Act. If you look at the telco sector, telecommunications platforms I actually like to talk about this for a moment, because it's a lot of negativity that you normally see in the media or in the news. But actually, if you look at how telecommunication platforms can be used for greater social good, you'd see there are a lot of examples. I've just listed out a few. I'm not going to go into each one because I'm very conscious of the time constraints that we have. But you see, even during COVID, during the pandemic, the telco platforms world over have been used using their anonymized data sets to help curb the spread of the virus. In Pakistan, you've seen how they've done a model to control the spread of dengue fever using anonymized mobility data, CDR and analytics, anonymized, of course. But if you use the data responsibly, you can bring better, more reliable products and services to your customers. You can serve a vast majority of people. Like you can even reach people who the traditional channels wouldn't be able to reach, because if you look, I'm talking specifically on Sri Lanka. If you look at the landscape today, from the bottom of the pyramid has a mobile phone. Everyone has a mobile phone, and you can really reach the unreached through the telco networks. So in doing all this, it's very important that there's a law like the PDPA in place, because it enables the responsible use of data, where you could do things, you're mandated to do things, and it makes it legitimate also what you do if you fit into the confines of the law. And that would ultimately enable a greater good, where so many people can benefit. So it's a positive sum. It's a win-win situation. So you could use a lot of tools. For example, privacy by design. It's I think crucial to doing any of these things that you want to do using the telco platforms, where you incorporate privacy considerations into the product at the point you build it. You build it into the architecture of it, or you conduct data protection impact assessments. Under the law, there are certain instances where you're supposed to do the impact assessment. But if you incorporate that as a practice into your day-to-day activities, you can really gain a huge benefit by doing that, because you cover every possible angle. Additionally, there are privacy enhancing tools which you can implement in your systems to ensure that there's no manipulation of the data, and that anything that is done with the data is done with a if you, let's say you're transferring data, you do it machine to machine, there's no manual intervention. So the leakages, all that you can control if you do that. Then if you have in place a data protection management program and incorporate all these things into it, you can really use the data that you hold for a greater good. In terms of the telco sector, it's no secret that incorporating privacy practices would definitely protect your consumers, because you have consumers who are maybe at the moment not conscious enough of their rights, but I think there are people who are becoming conscious of it. So in ensuring that you put in place the right practices, you're protecting your consumers from illegal activities, then you're protecting their data when you use it, when you store it, then you protect public safety, because your networks are, by incorporating the relevant security practices, you safeguard the data from getting into the wrong hands, and you will protect your networks and even the devices from any unnecessary tampering. So I think definitely the law has a lot of benefits, and I'm really glad that Sonali actually brought out a lot of things that I've been thinking about, and it's something we've been advocating very fiercely on, having the right processes in place and the training, and how people can be your weakest link. I mean, that I think, and the training aspect, I would really like to echo those thoughts, because it's fundamental that you get it right when you're dealing with such a vast amount of data, be it telco sector or any sector for that matter. So thanks, Anthony. I think that's about it from my end regarding the slides. So.
Thank you, Shanika, for that very interesting overview of how the intersection between the Sri Lanka Telecommunications Act, especially license conditions, and how that play out in the expectations under the PDPA as well. So I'd like to invite the audience also to raise any questions that they might have in the Q&A, so which we can direct to our panelists. So just to start the discussion, I'd like to involve back to Jayanta and ask him about, often you spoke about I think during the whole of this evening, we mentioned about the importance of having an effective data protection authority, having an authority with teeth, so to speak. And often setting up a new regulatory body is criticized as an additional burden on the government expenditure. I mean, it's a criticism that often comes in from various quarters. And in the current economic climate, what are the benefits that you see in setting up a comprehensive data protection authority that may be considered to outweigh such concerns?
Thank you very much, Sadhuni. It's a tough call, a tough question to answer, since we are not engaged in the regulation of it, of a law that we may have had a hand in formulating and drafting. What's noteworthy is the fact that if one were to look at Chapter 5 of the Act, which contains the framework for the new Data Protection Authority, we would see some very unique provisions, namely the fact that it has a fair degree of freedom under its powers and functions to operate in a manner that it would hold inquiries, give directions for the proper implementation of the Act, and a variety of other provisions are there under the powers and functions under Section 32. Its overall objectives are spelled out as being not only to regulate processing of personal data, but to safeguard the privacy of data subjects from any adverse impact arising from digitization, both in the public and private sector. So you can see the sweeping cross-sectoral impact this has. And then to ensure the protection of personal data of data subjects engaged in digital transactions and communication. So there's a lot of emphasis to digital commerce, trade, and digitization in general across government and private sector. So in the how I would address your question, Sadhuni, is in the context of digitization initiatives, in the context of a paperless kind of atmosphere that we are living in, to save costs incurred by government and private sector in doing their regular transactions, and to improve efficiency in the delivery of public service. It's imperative that trust and confidence is built for individuals to use these systems, knowing that they are truly well protected. There is no better entity that can ensure that than the future regulator for data protection, because it has the regulatory and compliance remit, right? And of course, we have to take note of the fact that unlike other regulatory entities in Sri Lanka, where the board and the chairman, as well as the director general, are appointed through the statute by the executive authority of the country. In this act, while the board and the chairman is appointed by the executive authority, the selection of the director general is to be done through a public, transparent process to be formulated by rules made under the Act. So there are a number of interesting facets that need to be highlighted when we look at the Data Protection Authority, which was not easy compromise to reach in the parliamentary select committees and all that. But in that context, there is a tremendous opportunity for the country to move up in its value chain in terms of international trade, international commerce, not only in terms of digitization overall in the country, in the context of GSP plus and the general trading services under the WTO arrangement to enhance efficiency of that and to attract investments. significantly into Sri Lanka. In that overall context, the regulatory authority plays a pivotal role. So there is a cost benefit that can accrue if the relevant authorities take cognizance of these factors in setting up a data protection authority in future. I mean, this is what I can say at this moment in time. I'm here addressing a regional ASEAN regional session on electronic evidence. There were discussions not only on electronic evidence, but on cross-border data flows, how those can be enhanced, not only in the area of cybercrime, cybersecurity, but in the realm of anti-corruption drives, in the context of access to information in all kinds of investigations, including under the evidence convention, right? So in the broader realm of all these, the supervisory authority or the regulator will have a pivotal role, and the cost benefit, I think, would outweigh the issues that many raise in terms of the economic climate, the expenditure any government entity would have to bear in terms of setting up an authority. We all know the current challenges we have back home, but nevertheless, we have to take, it's up to the relevant authorities maybe to have at an initial phase, certain competent people may be seconded from other regulators like central bank, which has got a very good pool of Basel II or Basel III certified banking supervision experts. Then we have trained people in the SEC. So maybe perhaps in the interim phase, I'm just speaking aloud, I can't speak for the relevant authorities, but maybe a task force comprising of SEC, central bank, as well as TRC and other relevant regulators may join hands to work together to pool their resources in until such time a fully fledged regulator is established. That's kind of a out of the box model I'm thinking of as an interim phase, if the relevant authorities are inclined to get this as a way forward. Thank you.
Thanks, Jayanta. So we have a series of questions coming up on our chat as well. So I'd like to put this question out to Shanuka as well as Raina, because Raina spoke extensively about the kind of trust and accountability framework that you already have implemented at Meta. So drawing from your experience, so the question is about a data protection management program, which I think the provisions in section 12 of our act mimics or aligns quite well with what you discussed as well. So the question is, can a company just comply with the act without really adopting or embracing a data protection management program? What will be your thoughts on that? Raina and Shanuka, if you can add your thoughts.
Should I start? Okay, so I think a data protection management program, my view, it is essential to have in place, because otherwise it's like navigating without a map. So the data protection management program really would set the tone for where you want to go, and you can chart your course and you know which milestones you need to achieve. Also, it will bring some sort of logic and sense to what you're doing, because complying with the act is by no means an easy task. It's there are lots of obligations. It's new to you, and you might be an organization that suddenly finds out, I have so much of data that it's residing in my systems, and what do I do with it? So if you don't have a plan where you go through your stages of assessing what you have and figuring out where your data is coming from, what your data is, and what you need to do, and whether you really need all that data. So if you don't have a plan in place, that wouldn't happen. Then the plan would also have things like training. It would also have security requirements that you need to build in. It would also have the monitoring mechanisms. So I'd say a plan is essential. So Raina, over to you.
Thank you. And I agree with what Shanuka just said. And I think accountability or the data management system, however you call it, is a mechanism that we can leverage when making decisions that are considerate of protecting privacy and balancing against other human rights as well. Because well, I think when we make decisions on how to use personal data in tools that are built for safety and security purposes, and when sometimes we need to make decisions about, can we use data for a particular build product and there's some particular risk. I think if you don't have an accountability system or privacy review process or people from different cross-functional team to look at it, then basically, I think there won't be any consistency in terms of the processes. So I think the beauty of having accountability is you have a structure. So it allows, I mean, for us, for example, the privacy review process, it allows us to evaluate and build new products to prevent problems that could cause harm to our communities. So we go through the privacy review process to evaluate what data is needed for a particular purpose and ask if the benefit of the use is greater than the sensitivity of the data itself. So to us, we think the privacy review process that we put in place is very important, and the structure of having cross-functional teams evaluate the particular new use of data for a particular product. And also we think that it is something that, and I think the having the program like independent, we have independent assessors and internal assessors that assess that our system is also something that keep us accountable. And it's making sure that we have some third party, like it's almost like a certification. It's not like we go out say that, okay, these are our privacy commitments that we make. And we actually have someone who actually verify, and we have these independent assessors that verifies and they actually do independent audit and make a report to the privacy committee at the board level. So we think that this is something that we can, we are a big company and we handle a lot of data, and we have someone who actually can verify and look into our system and keep us honest and make sure that we keep improving. So we think that this is something we from our point of view, and I think people, as a company of our size, people have expectations or not. And I think if we have independent assessors who come in and assess our system and make report to the independent privacy committee, I think this is something, it's almost like a certification of how good we're doing in terms of what we want, we hold ourselves out. So we think this is, for us, we think this is something that we think is a good system.
Thanks, Ran. And I think I quite agree with your thoughts as well, because I don't think one can achieve the full extent of the compliance requirement under the PDPA without leaving behind the data protection management framework which is built into the Act. And so I'd like to take another question from the audience about the DPIA, and I'd like to invite all panelists to chip in. Share your thoughts on this, because on the question of DPIA, so under the Personal Data Protection Act in Sri Lanka, it's an obligation that is vested with the controller to conduct DPIAs in certain circumstances where the risk of harm towards data subjects is considered, considered as high. And there are certain instances which rules is going to define once the Data Protection Authority is in place. So the question is whether a DPIA has to be carried out for any processing activity. So essentially, obviously, there will be prescribed activities, but what are your thoughts on carrying out a DPIA? And if I may extend this question a little further, what are the factors that you would recommend that should be taken into account when an organization as a controller carries out data protection impact assessment? Maybe we start with Sonali.
So, Sandhani, your question is, what are the first steps to be taken when you do a data protection impact assessment? Is that what the fundamental question here is?
Yeah, so what would be the factors that one organization, a controller, needs to take into account when they carry out a DPIA? And do they need to do it for every processing activity? What would be your recommendation, essentially?
Thinking from the angle of a controller looking at a processor, I think you wouldn't be looking at every process, because I think when you set up the contract, you give them what you want. There is a design of a program that you're requesting, because you're not just going to give your data to someone without structure, right? So at that initial contract design and proposal design, you as a controller should definitely say, this is how we want our data protected, and these are the laws that we have to abide by. Now, if you take the healthcare industry, who's regulated under HIPAA, and for some reason they're doing some data processing in Sri Lanka with an IT services company, they would have to tell you, this is what the HIPAA Act actually wants us to do, and this is the type of things that we would like for you to align, because HIPAA particularly says, which is another big privacy act, exactly how the privacy rule and security rule should be extended, and that all third parties should match the controller. There should not be a difference. So it is up to the controller to actually establish what they require with clarity at the point of contract, at the point of giving away that information for processing. The second thing is to hold the right to audit it at the time that they design it, so that they can overrule the company's policies and regulations and go ahead and audit. So when you do a data impact assessment, particularly if you're giving the data, your first step is to understand what you want from them before you go and tell them you're missing these things. Because clarity is important. That's my view.
Thanks. So I think that's a very valuable point to raise. And any thoughts from the other panelists?
If I could just interject. So in terms of a data protection impact assessment, I'd like to say two main things. One is, if you are looking at doing a data protection impact assessment or a DPIA, my first step would be to look at to identify whether you are a controller or a processor in that instance, because it would really change the point of view of the data protection impact assessment. So you need to see what your involvement in the processing activity is, because there are in some cases that you may be obtaining the services of a third party, or you may be the third party that another person is obtaining the services from. So to limit your scope and exposure and to see what your obligations are, I'd say first identify whether you are a controller or processor in that instance. The other thing I'd like to bring out is that you need to always look at it very practically, because and not get bogged down by the technicality of certain things happening. So look at the process end to end and see where your risks are, see where the leaks are, how you can improve it, what security controls you need to implement. But always remember, look at it practically, because that really helps to bring clarity to the whole process.
Thanks, Shanaka. Any additional thoughts?
Something, the only point I want to add is that if one were to look at current provisions, there is an interplay in those points made by Sonali and Sheruka vis-a-vis the regulator as well. So if you look at the regulatory intervention under section 25, where a DPIA is carried out under the preceding provisions, and there is there's indication that the processing would result in risk or harm to the data subjects under the Act. then of course there are provisions where the authority can issue written instructions from time to time to the parties concerned. So the whole regulatory interventions and the parameters are also specified there. So in the context of the earlier question you posed on the importance of the regulator, perhaps one noteworthy justification is that the necessity for a regulator cannot be underestimated because of the interventions such entity would have across multiple provisions of the Act, including in respect of a DPIA. Right? Thanks.
Thanks, Jonathan. Thanks for bringing that legislative framework as to how it works under the PDPA. I'd like to take another question from the audience. I think this is mainly directed to Shanuka, I suppose, but I invite the other panelists also to bringing their views on this. So when it comes to implementation of privacy in the telco industry, I suppose it would apply to any tech service industry also. There's a huge communication gap between the privacy team and the key business teams in terms of understanding the importance of enforcing privacy into business operations. So how would you address that gap? And I'd like to invite both Raina, Sonali also to add into what Shanuka might have to say.
Okay, thanks, Sandhani. So in terms of the communication gap, I think your privacy program and your trainings would become very relevant. So if you have the program in place, you'd also have the team in place. You can't play a sport without a team, right? You need to have the team in place. So you need to get all the relevant actors, all the relevant stakeholders within your organization to one place and explain your roadmap to them, explain your plans, and you need to make them part of whatever outcome you hope to achieve. So it's a journey that you take together, and you need to basically show each person what their role in the whole thing is, individually as well as collectively. Also, I think going from what Sonali said earlier on the trainings, it's absolutely essential. And you can't use the conventional methods. I mean, I've seen this, I've said it a million times over also internally, because you people, I myself don't like those trainings, like to go through reading slide after slide and just answering a checkbox. I mean, the chances are you skip over the slides and you try your hand at whatever answer feels right. So that really wouldn't achieve your end. So I think the training part is crucial to ensure that everyone works together.
Thanks, Shanuka.
Yeah, can I just chime in here? So I think the gap, how to address the gap in communication. Actually, I think for any country that just adopts the first generation data protection law like Sri Lanka, I think basically it's social engineering. Because when you think about privacy, this term is, I still remember when I first started my first training contract work in Hong Kong, when at that time there was no data protection law. And I still remember my first assignment was by an associate solicitor asked me to send a letter. It was I was given a file, a running down case. So we were representing the plaintiff, and I was asked by my manager to send a letter to that to the defendant's employer, to the plaintiff's employer, to ask the plaintiff's employer to provide the plaintiff's salary history to us. So we didn't even ask for the plaintiff's consent. So we just sent a letter to the employer. But if you look at it nowadays, all this data, salary data is pretty personal, right? It's personal data. But at that time, there was no data protection law in Hong Kong. So people, they don't know, well, this salary information, it's sensitive, it's private, it's personal data. And I just prepare a letter and send it, and then people will just reply and provide all the salary data. But you just can't, I mean, so people have no concept about personal data. and protection of personal data when you have no data protection law. So now in countries where they just, I've looked at countries that first that adopt data protection law. So the beginning, I think it's social engineering, because you need to educate both, not just businesses who handle personal data, but also individuals about what is personal data and their personal data rights. So I think, and when we talk about educating businesses, and businesses a lot of times and historically, it's not until GDPR, actually data protection is not a priority for most companies. But GDPR has changed all that because of the very substantial fine that it has given the supervising authority to impose. So now GDPR becomes a board level discussion, and data protection, it has been brought into mainstream. So I think for a lot of the businesses, in countries like Sri Lanka, when there's new data protection law, I think for businesses to understand and embrace that, well, this is good. This is not. We need to invest in putting together a data management system. We need to invest in good data practices, because this is a business good. I think this is still something that from people who are doing data privacy, like myself, or I'm sure a lot of the people who are on this call, it is something that we need to persuade, especially the management, because tone from the top is very important. Because if you don't have the senior management's support, it's very hard for us, for our job, to tell the business people that, well, this is important, we need to do this. So actually, I think it's very important to focus on communicating the importance and the ramifications and negative consequence of the fine, and the cost of compliance is actually cheaper than the fine. I think it's important to bring this matter across to the senior management, so that there is a tone from the top to say that I think it's easier for our jobs, for privacy people, if the tone from the top, the senior management say that, oh, this is important, we need to comply. Otherwise, it will be very, very difficult for us to try to change culture from bottom up. So I feel that the communication gap is one issue, but I think the most important, and I've heard a lot about this when I joined different data protection officers group. I think the chief, when we identify as the most difficult part in our job, is really to make senior management understand that this is important. Because if they don't embrace this, it's hard for us to try to change culture. Yeah, so that, yeah, I think this is what I want to share.
Thank you, Raina.
Is it possible for me to add? Or okay. So one practical aspect I want to bring in here is, in addition to what Raina and Shinaka mentioned, on top of the training, on top of the awareness, is when you set up your privacy program, right? One of the first things you have to do is to identify the internal data owners. So that you could be having one database with lots of information, whether it is coming from an external source or an internal source, but who are the custodians of that data? You have your HR department, you have your travel department, you have your clients, right? But particularly when it comes to addressing the gap between what the company is driving in data protection and what the data owners know, or the custodians know. To bridge the gap is when you actually set up your data program, you have to push that accountability to those people. You have to say, as a part of your department protocol, it is up to you to go ahead and spell out and decide how you are going to work with the data privacy office, how you're going to work with your security teams, how you're going to work with your what you call your applications group. In keeping this data secure, it has to be a part of their job description as well. That's the way that you actually close that gap. It has to be, say, I'm the head of HR. I'm not only about recruitment and, you know, sexual harassment and all of that stuff. I'm also a person who's protecting the data I have collected. And that has to be really well spelled out. And that if anything goes wrong, that person should be accountable. so that accountability set up at the very beginning has to be established. And there has to be this connecting forums that have brought this up where legal privacy officer gets together with these people periodically and informs them of any changes and vice versa. That's the one I wanted to bring up. Thanks, Cindy.
Sorry, Jayant, I would like to add something to the discussion. No. So thank you. Sorry. So thank you for your thoughts. And I think in the interest of time, I think we have time for just one more question. So I'll just, put it out there and feel free to request the panelists to answer this question. So if a company is compliant under PDPA, would this be sufficient to be GDPR compliant? And this is where company act as data processor or controller for European citizens. I think usually the question we get is the other way around. If you're already GDPR compliant, would be considered as PDPA compliant as well. So, but I'd like to have your thoughts on this and say, what additional measures should local controllers should consider taking? Maybe this is something Jayanta and Shanuka would like to comment on.
Maybe I'll ask the industry experts, Raina, Shanuka, and Sonali to go first, and I will put the bit of icing on it. Shanuka or Raina?
I'd say there are different laws, so the requirements may be slightly different. Generally, we say if you're GDPR compliant, then you should be compliant with the local act. But there are certain differences which maybe Jayanta could shed some light on. So I think you need to look at each piece of legislation by itself and look at complying with that as a first step.
Thanks, Shanuka.
Yeah, I think Shanura is right. And because there are some differences with the GDPR, although the Sri Lanka PDPA is largely very similar to the GDPR, but it's not entirely the same. So I think it's not just, it really depends on the exactly your data processing activities and exactly what you are thinking about. So it has to be a clause by clause analysis. I mean, if you really want to be sure whether you are GDPR compliant, so I think it probably needs to take a deeper dive into exactly your data processing activities and to see whether you're GDPR compliant.
Thanks,
I want
Raina.
to bring an additional view here. So the question is coming from a broader space, I think, where eventually there are lots of companies who have to face multiple privacy laws. In this case, it's PDPA and GDPR, but then there are companies who have to align to GDPR, PDPA, then they have the Gramm-Leach-Bliley Act from somewhere, or the National Patriotic Act, or HIPAA. So now you have a whole suite of privacy acts. The difficulty that's coming here is that same concept. And eventually, as companies get larger and expand their space in the international market, the number of privacy laws they'll have to face will increase. So how do you keep up with this is the first question. And the first thing is to form a strong privacy base, because if you take all of the privacy laws, there's a base that applies to all of them that is common. And you need an expert to help you identify that common base first. Your legal can do that for you, privacy expert can do that for you. Once you actually identify that privacy base, and of course that is after knowing what type of data you process, and in this case it's EU citizen data, then you can build up. And that's going back to what Raina and Shanuka said of the importance of a privacy program, because you cannot face complexity without a program. And a program helps you actually establish a base, an operating base for privacy. And from that base onwards, you have to have an expert help you to build little additional areas to align. So it's not actually measuring the gap between the two. It's arriving at a stable base and then accounting for the differences.
Thanks, Sonali.
Yeah, so if I'm to add to that, I agree with all of what was said by Raina, Sonali, and Shenuka. And suddenly, if you look at the perspective given by Professor Zwain earlier today, I think what's notable factor that all of you said and what he said is the fact that every country and jurisdiction would have their own context. You would also see this in the context of the domestic framework and the various state laws, the diversity of state laws in the US. There is no federal statute, although there are efforts at those over the years. You have a very strong regime in the state of California, which is quite rigid, perhaps going beyond GDPR. And then we have GDPR having an overarching effect as one standard. And Raina noted that its outreach impact has compelled companies doing work in processing European citizen data or doing business in Europe to take a look at their processing activity and align their internal governance framework in line with those standards. So there are a number of facets that one has to look at before we can compare the two. But if you look at the overall aspect, I agree with the keynote speaker and the panelists that we have broadly introduced a framework which resembles the underlying principles of GDPR, but one noteworthy difference, of course, is that despite many interventions, we have taken a different approach in terms of the fines, not a percentage of the revenue. There's a maximum, there's a cap, and of course, with the depreciation of the rupee against the dollar, it's not a big amount for international companies, but for local companies, yes, the regulatory impact may be significant. But what is also noteworthy is the point, I think, that was emphasized by Shenuka and other speakers, of the overall benefit of the data protection management program that comes out in section 12, which is not a feature you find in GDPR, which is more APAC privacy framework, or maybe based on what you find in Singapore and other places where you have a self-governing option, a self-governing formula, have your internal processes aligned with the data protection management program, which will in turn help you mitigate and manage a situation if there is a regulatory intervention to impose fines after an inquiry. If you look at the mitigation factors in section 39, the fact that you have a data protection management program running, an effective program running, is a mitigation factor. So you can look at all these aspects and see for yourself the differences and similarities. And of course, if you look at the preamble, you talk of the law being done with the intention of having a synergy and cross-border cooperation amongst data protection enforcement authorities, which would mean that in the future, Sri Lanka would be able to become part of the Global Data Protection Academy. Regulatory folks will be able to be part of it. And there are tremendous benefits thereafter flowing from it, including adequacy kind of a discussion. We can't predict how that will go because there are a number of geopolitical issues that intersect in that discussion. But that's for the future. But at present, what we need to do is more awareness, capacity building, and hopefully if a regulator is established by early next year, they should endeavor to provide certification or standardization mechanisms so that we'll have a number of certified bodies to do training, capacity building, maybe in collaboration with IAPP. So a lot of work needs to be done, and a comparison between these two regimes may be a part of a PhD thesis or a research and analysis activity. I'm not having the time to do that, but I think many young people could take this to a next level so that we can be part of a global ecosystem and build a culture of privacy that would stand well to help reset economy and the country going forward. So that's broadly what I said. I'm just giving a slightly bit of a vague answer, but trying to address it, skirting the issue around in the best way possible, because my brief is not very strong on that point. Thank you.
Thanks, Jayanta. Thank you for the insights. And just a final question, just for a very quick response. I think that's the last one remaining on the tab. Can data protection be carried out without the use of tools or privacy by design concepts? And I think this question reminds me of, looking at the PDPA as an opportunity to get into this field of developing tools and, operationalizing privacy by design techniques. So what are your thoughts on, what is the role of privacy by design concept and use of privacy enhancing tools and technologies in the context of achieving compliance under PDPA? Just very brief feedback from you all, please.
Maybe I'll take the question on tools because of the scale that we are operating, we use a lot of tools for example, like we have tools that allow users to access the data, to download the data, to delete the data, because we have a very big user base. So I think tools is very important to us in terms of like how we comply with the PDPA. And also I think this is an area where there's opportunities for Sri Lanka businesses to really like build tools to allow people to help companies or businesses to comply with the PDPA, because we've seen there's a very big industry being out there after GDPR that actually provide this type of tools to help people to comply with the GDPR. So I think that there's actually opportunity there for Sri Lanka businesses.
Thank you, Ryan. I think that's very helpful. Any additional thoughts? Okay, so I think we can bring our panel discussion to a close now, and we're almost at time. So thank you again to Jayanta, Raina, Sonali, and Shanuka for sharing their thoughts for a good 1.5 hours, and for joining us from the start of the session as well, and taking time off your busy schedule to speak to us, share insights with the Sri Lankan audience. And I'm sure they stand to gain a lot from your feedback, your interventions, and the responses you gave to all their questions. And I hope you had a fruitful time engaging in this discussion as well. So with that.
Thank you very much, Sandhini, and to all the panelists. Thank you.
And thank you for Ceylon Chamber of Commerce for facilitating this workshop. And please, I'll kindly request the audience to send in their feedback in the participant survey so we can curate our next workshops based on your feedback, so that it'll be more useful for you. So with that, I'd like to wrap it up and wish you all a very good evening. Thank you.
Thank you.
Bye.